Hello and welcome to another episode of Litigious, a podcast discussing legal issues in the news, legal stories in the news, and breaking them down from a real world perspective. I'm Scott Peterson, as always, joined by Giovanna. Just a reminder, this podcast is brought to you by DeRazio Peterson, a plaintiff side employment and serious injury law firm serving clients in New York, Massachusetts, and Vermont. Also, a reminder that if you're enjoying the show, please continue to like, subscribe, share. The metrics are telling us that more people are watching, listening, and we love it. We appreciate it. And if you have questions, feel free to reach out to us on Instagram at Litigious Podcast, and we will try to address them. We're happy to talk about things that folks have questions about. So we will jump right into it today. We're moving away from the last couple of weeks, which were pretty heavy episodes talking about the shooting in Minnesota and some other fallout from that, and some of the fallout from the Charlie Kirk shooting again. This week, we're going to talk a little bit less heavy and jump into a couple of topics or at least one topic that we talked about previously. We talked a lot last year about the lawsuits arising out of the It Ends With Us movie involving Justin Baldoni and Blake Lively. There have been some recent updates in those cases, and in particular, as they relate to what we do, the Baldoni folks have filed what is known as a motion for summary judgment, looking to have some of the claims dismissed, and in particular, having the sexual harassment claims and the retaliation claims dismissed. So, why don't you give a little more context as to what those claims are, and then we can talk about kind of what the standard looks like and why there's always a possibility that they could be successful in that.
Yeah, so procedurally, a motion for summary judgment is something that happens in a lot of litigation, which is a motion that a defendant, typically a plaintiff can do it too, but it's usually more commonly the defendant, that at the end of discovery, meaning at the end of the exchange of all the documents and at the end of depositions, they go to the court and they say, here's all the facts that have shaken out in this case. And even if we look at these facts in a favorable light to the plaintiff, when we apply the law to these facts, the plaintiff has no case and it should not continue to trial. So that's the motion that they have made here. And there's several different pieces of it in terms of arguments that they're making and claims that they're trying to have dismissed. But I think the ones that are the most sort of relevant to our practice and that are the most maybe newsworthy are the sexual harassment claims and the retaliation claim. Um, so do
Let's
we could
start with
talk about,
section. Let's start with the sexual harassment claim. So, um, give the context of just a reminder to anyone listening what it is that she's claiming constituted sexual harassment, and then we can talk about why it might not be severe and pervasive enough legally.
yeah, she has a lot of, I mean, people have probably seen this reported in the news. I mean, she has a lot of different what she describes as sort of sexually charged or uncomfortable interactions with Baldoni and with some of the other people involved in the movie, where, you know, one of the producers came into her trailer while she was breastfeeding and she wasn't covered up. Some issues about, you know, unscripted kisses, comments about her body, and just also, I think they're alleging kind of an overall sort of either sexually charged or misogynistic kind of atmosphere. And that's sort of the basis for her sexual harassment claims. And those are things that she complained about while the film was on a hiatus. And her complaint is what is sort of underlying then this second retaliation claim.
So what is she saying that they did after she complained?
Well, I guess that's like jumping ahead a little to the retaliation. I mean, do you want to talk about the sexual harassment, like what the standard is and what she
Yeah,
has to prove?
sure.
So,
This is wait, just the reminder. This is in the New York case or a California case?
New York. Now,
Yeah.
there are some California claims in there, so it's a little jumbled up sometimes whether they're citing New York law or California law. But the New York law, I think the Second Circuit law, which is the appeals court in New York, is driving the Title VII claims. Um,
Okay.
So basically, the standard in a sexual harassment case or any hostile work environment case is whether the conduct that you're complaining about is so severe and pervasive that it, what they say, alters the terms and conditions of your employment. So basically, it's so severe that you really can't do your job and that a reasonable person would really not be able to do their job under these circumstances. And one of the things that's coming into play here is that's has an objective and subjective component to it. And another piece that's at play here is, are you receiving that harassment because of your protected status? So not only do you have to prove this sort of offensive conduct and that it's so severe that it's interfering with your ability to do your job, you have to prove that you felt that way, that an objective person would have felt that way, and that you are being targeted for a reason that the law protects. Because we are not protected from an inappropriate, gross, obnoxious, mean, nasty work environment unless we're being targeted because we're a woman or because we're black or because we have a disability or something like that. I shouldn't say disability. The law is up in the air about hostile work environment for disabilities. But, in this context, she has to be being targeted because she's a woman. So they're
Correct.
doing not only is what you're describing, even if we take it as true, not severe and pervasive, but none of this was targeted at you because you're a woman. It just was the nature of the movie set.
And is she alleging that this was just him, or that there were other people involved in the harassment?
Yeah, I forget what his name is, but there's another guy that's basically his producing partner, and he's the one who I think walked in on her while she was breastfeeding. I think he might also be the one who they shared like a birth video of his
Oh yeah.
wife. Um,
But
you know,
just to touch on that for a second, we talk. I occasionally do a training for some smaller businesses and as who are clients, and then we often see cases of potential sexual harassment or harassment, and that don't necessarily rise to this level, or that don't involve aren't necessarily cannot necessarily be attributed to one of the protected statuses that you mentioned. And I always use the example that, it's not illegal for people who you work with or a boss in particular to just be a jerk. They can, if they're targeting you because of a protected status, that's one thing. But if they're targeting you because they're just a bad person to work for, that's not illegal. It's creating an uncomfortable workplace. We've talked in the past probably, and we get calls from people who complain about being bullied at work, who complain about what they think is a quote unquote hostile work environment, but it's not related to any protected status. And the answer is typically, that's actually not illegal. It doesn't create a good work environment. It's not good for morale, not good for business probably, but it's also doesn't give you a right to file a lawsuit successfully.
yeah, and there's a lot of Title VII case law that says, Title VII is not a civility code. And part of that case law, and then also having this sort of objective standard, does protect employers from people being, maybe not having an objectively reasonable reaction to what's going on in the workplace.
Yeah.
Something that's very offensive to one person is not offensive to another person. That's not an excuse if the harassment is pointed at you based upon your protected status, but there is an understanding in the law that, every workplace is not going to be perfect and that you're going to hear offensive things occasionally. And they're not, there's all these little catchphrases in the case law about like errant comments and, things like that. So you're not entitled necessarily to a workplace that is sort of perfect all the time. Um, so I do think that this I thought their motion, so I read the memo of law and then the opposition memo of law from Blake Lively's people. And, it's certainly, these people have good lawyers and you make the best argument that you possibly can with the case. There's so much case law on this that usually you can, put together a decent amount of case law on both sides. I do think it's going to be a little bit difficult for her. Like the severe and pervasive standard is pretty high. In New York, I should add a little footnote that we've actually removed that standard. So in New York, under the state human rights law, it's a little bit easier to prove a hostile work environment. But, under Title VII, you still have this standard. And I do think it's going to be, I thought it was a persuasive argument that potentially she wasn't targeted because of her gender, specifically. I thought it was, there's a lot of case law out there that they have cited to that I think is helpful to their claim, which is in terms of looking at the context that you're in, you know, that when you're on sort of a movie set, if the movie is like sexually charged, with which this one was, if it's like a raunchy adult comedy or something, I think we can all understand that you can have a movie about those themes and still have a very professional environment when you're not on camera. And
Yeah,
I'm
of
sure
course.
that that's the argument that her side will be making, that this, there was no excuse for this sexually charged stuff to sort of spill over into the behind the scenes. But it is relevant that, if you're making a movie that has sexual themes in it, that might be, discussions that you have, or that you might have discussions about, your wardrobe, and things like that, that might make you feel like someone's commenting on my body, but it's not quite in the same situation as if, they made an analogy that was sort of like, this is a little bit different than if you work, at the bank and the guy sitting next to you suddenly starts, commenting on how sexy you look that day. Is that a
Yeah.
little bit different than when you're on a movie set and part of your costume of that day is to appear physically in a certain way, and somebody happens to say, oh, that looks hot.
Yeah.
Is that, I don't know if that's objectively hostile or not. So, I thought there were some persuasive arguments to be made there. That being said, in terms of the context, there's definitely cases out there about like people sexually harassing people in like strip clubs and stuff like that. Just because you're in a sexual environment doesn't mean that you're allowed to do whatever you want. People have no recourse.
No,
Um,
I know a lawyer in New York who made several years worth of cases on suing strip clubs in New York on behalf of dancers who were being
yeah, that
sexually
was
harassed.
my
Yeah,
friend that I went to college with, his brother. Yeah.
yeah. So that is definitely a claim. All right. Well, so what gets people into trouble from an employment perspective often is it's sort of like it's never the crime, it's the cover up. Well, in this world, in discrimination cases, often it's not the underlying conduct, but it's the retaliation. So somebody makes a complaint that is protected, and in response, the employer has a trigger reaction and either fires the person or takes some kind of negative action against them in the workplace. We see these kinds of claims often, and in many cases, they are as or more successful than the underlying claim. So here, what's the retaliation claim all about, and what do you think there's any chance of the claim getting dismissed, or do you think it's potentially successful?
Yeah, so the retaliation is, so as background, the only time the law protects us from retaliation is when the underlying complaint that we made is a complaint of illegal conduct. So in this case, that's not really an issue. She did go to them, she did make in writing a complaint of sexual harassment. So I think they're not even really challenging that she engaged in what's called protected activity. And then you have to prove that whatever adverse action happened to you after that is connected to the protected activity and not for some other reason. So I think from the very beginning that we started talking about this case, we felt that one of the hardest things for her to prove is going to be that connection between this smear campaign that she has alleged and the protected activity of making the sexual harassment complaint, because we have this sort of separate component of what appears to be a total breakdown in their professional and creative relationship involving the final product of this movie. And I think it's a relatively persuasive argument on their end that everything that shook out after the movie was completed was potentially due to animosity over this creative breakdown and was not done to her in retaliation for making a complaint of sexual harassment. And I think what is sort of the legal issue here is that retaliation has the highest burden of proof for an employment plaintiff than a discrimination claim. So the standard in retaliation is but for, basically, this is why it happened.
Yeah.
Whereas in discrimination, if you get fired and you say, I was fired because of my gender, I was fired because of my race, there can be other things going on there, but as long as they took your protected status into consideration, you can still move forward. Retaliation is a more difficult standard. So they are, their arguments here are: one, there was no adverse employment action to begin with, because you need that to have something to challenge. And then two, even if there was an adverse employment action, they can't link the two things together. So that's the but for causation argument.
I mean, that seems like a fairly strong argument. Obviously, we haven't seen all the discovery in the case, but I think what you're saying makes it, that seems fairly persuasive to me.
Yeah, and I think that's, oh, sorry.
When we see these in successful cases, it's typically very clear. The timeline is typically what gets employers into trouble. Somebody makes a complaint that's protected and they get demoted or they get fired or their desk gets moved like within a week. It's very different from the situation here.
Yeah, and that's one of the arguments that they're making. So the legal language for that is temporal proximity. So it's funny because they're almost, in this situation, is a little bit different than what you usually see. Like a lot of times, um, we are sort of telling people you can't rely kind of on temporal proximity alone, because usually these things happen, they do happen right away. And you make your complaint and you get fired a couple weeks later. You have the temporal proximity in that situation, and absolutely that's something we rely on. But we usually tell people that to get further in the process and to get over one of these types of motions for summary judgment, you need more than temporal proximity. So here, they don't have really any temporal proximity. So they need like even more proof to kind of get to this but for causation standard, because there's such a disconnect between the timing of her complaint that she made and then this smear campaign. And I think the defendants, I think, have a persuasive argument, because they're basically saying she came to us with her protected complaint. We accepted it. We didn't think we had done anything wrong, but we, signed her piece of paper. We said we're going to put these protective, procedures in place moving forward for the rest of the movie. We finished the movie. They said there was no, now I don't know for sure how the facts shook out, but in their memo of law, at least they say that there's no instances of sexual harassment that she is alleging that take place after the date she made her complaint.
Yeah.
So they're basically saying, once you made your complaint, we dealt with it and everything was fine after that. Nobody retaliated against you. You didn't get kicked off of the movie. Nothing happened. And when all this creative stuff that's more newsworthy in the press comes out, their perspective is you actually ended up taking over the movie after that. You actually benefited after this. By the end of the movie, you were sort of in charge and doing everything the way you wanted to. So, how can you say then that 10 steps down the line, when we get involved in this sort of public back and forth of negative publicity, say, try to bring that all the way back to this complaint that you made? I think that's a relatively persuasive argument.
Where's this case venue? The Southern District?
Yeah.
So the Southern District of New York is a federal court that handles claims in southern part of New York and in Manhattan in particular. And they're a pretty serious court and pretty serious judges. And this will definitely be like a thorough analysis on the decision.
Well, one thing I thought was like a little bit, I kind of noticed it, and as an attorney, the Blake Lively in their motion on, especially on the sexual harassment, are citing a lot of California law. And I thought that was a little bit telling because I do think the law in the Second Circuit is, you know, might be a little bit tougher than the California law and also even just from New York State law. So, I do think they kind of have a little bit of an uphill battle. That being said, the standard on summary judgment is to take things in the light most favorable to the plaintiff when
Yeah.
it's the defendant making the motion. And the judge is not supposed to decide any factual disputes.
Yeah.
So typically, when you see the case law out there that says somebody's claim is appropriately dismissed, the court will make clear that they are taking everything that the plaintiff basically said as true
Yeah.
and applying it then to the law. So they're not going to necessarily minimize what you say or say, I'm rejecting your testimony. Like they can't do that. The judge can't, decide who's more credible at this point or whatever, but they can still say, look, we're going to take every single thing that you said is true, every single thing that you said that this guy did is true, but it either doesn't rise to the level of severe and pervasive, or you have no proof that you got targeted because you're a woman and not for some other reason, or that you can't make this link, that
Yeah.
you don't have any proof to tie those two things together. And the only other thing I had in my notes that I just wanted to mention that somebody might wonder is, even though this stuff all happened after the movie was over, you can have post-employment retaliation claims under Title VII. For more like regular people, you could see that most commonly in like a negative reference to an employer, to a
Yeah.
future employer. So, it is possible to have those types of claims. They're certainly not as straightforward as retaliation that happens while you're still employed, or the retaliation, or if you're fired and that's the retaliation you're alleging. But it is possible, as a threshold matter, that she could challenge this stuff that happened way later as being retaliation, but it's still going to be a challenge to make the connection.
Yeah. Well, the only other thing I'll say on that is, this is one of those things that makes headlines and, the headlines motion to dismiss big like it's big news. I will say, we are litigators. Motions for summary judgment happen routinely in cases. This is not like groundbreaking stuff. It happens all the time. We see, we fight these off as plaintiffs routinely in our cases. So, but it is a deciding moment in a case, and it could ultimately end up dismissing some of the claims or not. But all right, well, I think we'll move on from that.
Yeah, the only thing I wanted to add, just from sort of a newsworthy perspective, is one of the reasons why this was in the news is not only the motion, but what happened is that when the motions are made, you have to put in all of your proof.
Yeah,
So all these like text messages with Taylor Swift and like emails with Matt Damon and emails with Ben Affleck and the Ryan Reynolds getting involved, all this stuff saw the light of day. Because I think what happened is the court unsealed these declarations that had all the evidence attached to them, like maybe yesterday. There's still stuff that's sealed because I went down the docket. Some stuff is still sealed, but a lot of stuff saw the light of day yesterday. And that's why this was all in the news. And I just think, like, we've talked about this before. I mean, this could all shake out in her favor, and, her career could be rehabilitated, and she could look back on this and say, this was worth it. I got justice. That being said, I think for these really public people, you do have to understand, and we even tell our own clients this. I mean, I have this in the welcome letter that I use for employment clients. From this day forward, we will not talk about our case in writing. We won't text people. We won't email people about it, like, because they asked for this stuff now in this day and age. And, they clearly, the judge had all of these text messages and all of these emails, and everything that had to do with this dispute was fair game in discovery. And it's embarrassing. It's embarrassing for Blake Lively, like her. I understand these people are movie people, like, even though, like, you seem probably like a cool movie star on the outside, they are sort of like probably a little bit like theater nerdy, and some of their emails are kind of cringe, as the kids would say. And it's embarrassing. And like Taylor Swift got pulled into it, and her texts are, not probably not viewed in a super nice light. Apparently, she had to turn all her comments off on her social media. I'm sure Ben Affleck and Matt Damon, who are like making the rounds right now for a movie coming out, are like, oh, great, now I got to get sucked into this too. Um,
Yep.
and because it's all like the standard in discovery is relevance. So, and it doesn't have to be, something that is maybe used at a trial someday, but they are allowed to dig into all this stuff, and it's public.
Yep. Be careful what you wish for.
Yeah,
That's
be careful. And I think it just always goes back to like, be careful what you put in writing, because if you have any sort of dispute going on in your life, and there could even be the potential of, um, you know, litigation or some issue, you want to be cautious about what you put in writing.
Yep. Totally agree. All right, let's move on from that. Couple more topics. Wanted to talk about a jury verdict that or a bench verdict in Georgia. So, because this is something that comes up in the real world, not uncommonly. A Georgia judge awarded $52 million in damages to the family of an Army veteran who died following a cosmetic procedure at a clinic. Um, So the woman, Jordan, a mother of three and a nurse, died in December of 2019 from brain damage caused by oxygen deprivation during a liposuction and Brazilian butt lift procedure at a clinic in Georgia. This was apparently what's known as a pop-up cosmetic clinic, which I actually didn't really know that these existed. But so the judge awarded the estate $36 million for pain and suffering and wrongful death. Just to quick breakdown on that. When somebody dies and they file a lawsuit, there's two claims basically. Their estate files a lawsuit for wrongful death, which in New York is the economic loss and the loss of guidance and support to minor children that the death has caused to the family, to the estate, and the beneficiaries of the estate. The other piece of the case is for the conscious pain and suffering that the person suffered after and as a result of the negligence before they died. So there's two claims. And in this case, the judge awarded 36 million for wrongful death and 16 million for pain and suffering. Um, Despite this, the attorney, and the reason this made the news, this is obviously a big number, but big numbers happen all the time in these cases. But the the clinic did not have or did not have medical liability insurance. So the family is left out in the cold because apparently there's no or limited oversight, and there's no necessary requirement that these clinics have appropriate insurance or that anyone's checking in on it. Now, the doctor who was involved did settle the case separately, but this is a sort of misleading headline to the extent that there's this big verdict, but they may never collect on it. And this does come up in the context of, our practice as well, where you get, somebody is hurt because of some wrongdoer and the entity doesn't have insurance or the individual doesn't have insurance. And you try to vet these things out beforehand, but this is a pretty brutal result.
Yeah, so I think I don't know, I'm assuming the law is different in New York versus Georgia. I mean, this is one of those things where, people don't like regulation, but this is an area that you obviously need to be regulated because these people can literally kill you if they don't know what they're doing.
Yep.
And there's actually been a pretty recent crackdown in New York of medi spas that are basically engaging in the unlicensed practice of medicine. So I was looking on the New York State, what is this? Like the Department of Health, the Department of State, recently issued a whole warning to consumers after investigating med spa service providers, and they have a
Yep.
whole list of um, procedures that require a medical license to perform. I actually didn't know this about some of them because it includes like injecting Botox and fillers, um, cool sculpting. I mean, liposuction, that makes sense. That's a surgery, but any laser procedure other than laser hair removal, dermal peels, removing skin tags, like performing an ultrasound.
Yeah, and
There's
I
like
saw those emails last couple of weeks. I saw a bunch of them. I don't know if it had anything to do with this particular case, but that's an important crackdown because people don't know this.
Yeah, yeah. And I mean, the one in Georgia was an extreme. I mean, this is like anybody's worst nightmare. Apparently, she was supposed to be on a general anesthesia and like she wasn't even hooked up to oxygen, so she basically suffocated. I mean, this like horrible.
Yeah.
And in terms of those big numbers, I mean, you touched on this, like on the wrongful death piece, if you are um a provider for your family, those numbers can get very big. And this was an employed woman with a spouse with children. Um, you want to touch upon the Grieving Families Act in New York that's getting nowhere, which would make this a potentially very different situation in New York if you were just like a single person.
Yeah, so New York has one of it may be the only state, or it's one of like two states in the country that still has an archaic wrongful death statute, which only allows for basically damages, in a wrongful death case, economic damages as a result of, the loss of income to the family or support to the family. So there's no claim for the emotional distress that the death has caused to family members, including a spouse. And that people might think that that makes sense, except when you think about it from the perspective of an elderly person who is retired or a young person who doesn't have any income, those cases are quote unquote less valuable under the law than they would be in other states, and less valuable than a case involving someone who's our age and earning a living and supporting a family. And so practically the way that that works is that it makes it very hard for lawyers to bring those cases because they are expensive and the recoverable damages are often very limited. This is on our website, but one of the reasons that I used to do defense work and one of the reasons I shifted was because I had a conversation with an insurance adjuster at one point when I was defending these cases where they were dismissive of the life of an 18-year-old kid who got killed in a car accident because in their mind the case had no value because he wasn't earning any money. And I was like, I can't do this. So the legislature has passed, I think, at least three times the Grieving Families Act, which would allow emotional distress damages, among other things, in these kinds of cases. And Governor Hochul has vetoed it, I think, 3 years in a row now. So, we're
Yeah,
hoping that that changes. What's that?
oh no, I was just going to say it's totally unfair. I mean, I don't think you use the word child, but what people may not realize is like that applies to a child. So
Yep.
because your child is not earning any money. So if your child is the victim of some sort of horrible negligence, um, that unless they were suffering, which no parent would ever want their child to have conscious pain and suffering before they die, that's for sure. That case would not be worth, from a dollars and cents perspective, a significant amount of money as compared to a gainfully employed, adult. And it also, like I think you touched on the elderly. I think one of the things that advocates always point out, advocates of the Grievance and Families Act, is also um, what about people who are disabled who are unable to earn the same amount of money as someone else? Or what about, women's organizations fight against this because they say historically women can be, sort of underpaid versus men. So then therefore a woman's life is worth less than a man's life. It's
Yeah, and
really kind of not fair.
yeah, and I'll get off my soapbox in a second, but I do a fair amount of nursing home litigation in cases involving often like egregiously bad care that people receive in nursing homes, and results in these despicable ulcers and broken bones and all kinds of stuff, which is mostly preventable, by the way. And in those cases where someone passes away, it's in some ways it makes the case harder to pursue because the wrongful death statute does not provide for much economic benefit. Now, the public health law in New York does offer some additional remedies in that case, but and look, I think the counter to this, people would say, well, if you lose a child or if you lose an aging parent, you're just looking for it's just a money grab, and because they weren't contributing anything financially, you're just looking to gain from it. And I think that ignores the fact that, in our view at least, one of the things that lawsuits do, and especially lawsuits where there are significant awards, is that they help change the culture and that they help change the way people do things. And particularly in cases involving like institutional defendants, you know, getting hit with a big lawsuit is one way to ensure that policies, practices change and hopefully prevent these things from happening in the future. So, uh, that's a soapbox moment, but the long and the short of it is that, and the takeaway from this case that we're talking about is be very careful of the kinds of facilities that you're going to if you're using these types of pop-up cosmetic treatment centers, because if they don't have the appropriate insurance and they screw something up, you're going to be out in the cold. And uh, that's kind of the last place you want to be. So that's our PSA for today. Anything else on that?
No.
All right. One last lighter sort of discussion. You told me about this. My daughter accused me today of not knowing anything about pop culture.
Why?
So
Because of this?
no, some singer that I had never heard of. And I
Oh.
listened to a lot of music. It was just I don't know. Anyway, uh, the Beckhams are in the news, not in a good way, because the son, Brooklyn, has come out and posted a bunch of stuff online or on social media talking about how bad his parents are. Um, the reason that this is relevant to this podcast is because apparently there's a pretty good use of non-disclosure agreements in that family. So why don't you kind of talk about how these types, what the complaints are and how non-disclosures are used, and then we can talk about how we see these types of confidentiality slash non-disclosure agreements in our practice.
Okay. Well, just in case your algorithm did not feed you 8 million memes and reels and TikToks relating to this yesterday. Just the backstory on this is if people follow like the Beckhams on social media at all, you might be sort of aware of the fact that people have perceived sort of a rift between the Beckham family and their older son, Brooklyn, who is married to Nicola Peltz, who is an actress, but also, which is kind of relevant in this situation, the daughter of like a billionaire family from Florida. So people have always kind of talked a little bit about like, oh, it seems like now that he's married, there might be a rift between him and the family. He's not in all their family pictures and vacations and whatnot anymore. And I have no idea what happened behind the scenes to possess this man to air all of this dirty laundry in his Instagram stories the other day. But Brooklyn Beckham basically posted like 4 Instagram stories just sort of describing why, from his perspective, he's sort of estranged from his family and has no interest in reconciling with them. He kind of blames them for a lot of this sort of controlling behavior throughout his life. He says they only care about their brand. They tried to make him sign away the rights to his name. Um, all of this stuff, which may or may not be true. I mean, everybody knows, if anybody who knows me knows, I personally like Victoria Beckham. I have watched all their documentaries on Netflix or whatever, but I think most intelligent people can still say, I can be a fan of someone and I can think they're funny and whatever, and I still don't know anything about what goes on behind closed doors and what their true character really is or whatever. So all of this may be true. That being said, I still don't know why he felt the need to air this dirty laundry, because the thing that everyone sort of took from it is that one of his many grievances was that apparently Mark, is it Anthony? Not Anthony, like the historical figure, like the singer. Is it
Yeah.
Anthony?
Yeah.
Okay. Performed at his wedding. And instead of calling like him up to dance with his wife, he's apparently like a friend of the Beckham, so he called him to dance with his mother.
Okay.
And he says, my mother was dancing on me inappropriately, and it was the most humiliating moment of my life, and my wife had to like run away crying. So, regardless of like everything else that he said, which may or may not be like sympathetic towards him and show that his family is sort of toxic or whatever, the internet took that piece of it and had like a field day with, in my humble opinion, like hilarious videos about
All right.
Victoria
But
Beckham
but
dancing
how
on
does
her
this
other
relate to
son.
how does this relate to the NDAs is the question.
It relates to the NDAs because, like, release the video. I mean, we
All right.
want to see the video. We need to see it now. We have to know how
So
was she dancing on
all
it.
right. So because this is a legal podcast, so the claim is that that there's
Nobody
uncomfortable
has the video.
dancing, but
No,
nobody can release the videos because they are bound by NDAs.
or talk about it really. So apparently, so I was reading about the wedding. So the wedding had no cell phone policy. So nobody has this video on their phone, which would have been like ideal situation. Apparently, they have the only ownership rights to the actual wedding video that their wedding videographer took. And everybody who went to the wedding had to sign
An
an
NDA.
NDA. Um,
I have two comments.
so that's what?
I have some comments here.
This is the legal relevance to the podcast. So, do you want to say what an NDA is? Everybody knows, but
Yeah, first of all, we just started watching this show on Netflix called Sirens, which is actually pretty good, with Kevin Bacon and among other folks. But uh, two scenes from that show jump out at me. One, she's the woman, the owner, the very wealthy woman who's kind of the center of the show is played by Julianne.
Julianne Moore.
Yeah, she has everyone sign NDAs, and there's a scene in a car where one of the characters has to sign an NDA on an iPad, and it's very funny, and it seems probably like it's pretty accurate. The second is when you're talking about the Beckhams, there's this great scene where uh, sort of an outsider comes in and she's describing to another guest at a party that she stumbles into. She's like looking around, she's like, these people are awful. And the guest goes, look at this house. Of course they're awful because it's some like palatial estate. So it's like you have no idea what these people are like. Anyway, not NDAs are similar to confidentiality agreements in that they require you to keep confidential any information that you've learned. And the real issue with NDAs is the teeth that are often placed within the document. And most of these confidentiality slash NDA type agreements have what are known as liquidated damages clauses, which basically say if you violate this agreement, you're going to pay us all sorts of money. And oh, by the way, you're going to pay our attorney's fees if we ever have to come after you to enforce it. So, in most situations, probably involving these types of dynamics with one person who is wealthier and more powerful than everyone else, or the other people who are signing the NDA, there's a ton of leverage on the part of the wealthier or more powerful party because they have all the resources and the assets and they can crush the person who has signed the NDA in the event that they violate it. And so you get people who are signing these confidentiality agreements, and whether it's a wealthy person or a company, they're afraid to say anything because they don't want to get sued and they don't have the resources to defend themselves. And so that's what makes these things work. So, it's interesting. I feel like there's probably so many more NDAs out there than people actually realize in the context of celebrities. I bet they're everywhere.
Yeah, they probably have like their nannies and their assistants and everybody, which I get, you know.
Yeah.
I mean, this is a little, I would find it a little bit weird if somebody made me sign an NDA to go to their wedding. I could understand the cell phone, taking your cell phones and having like an anti-cell phone policy. There's some issues in New York about how enforceable these are, how specific are they written, are they totally unreasonable or not, are they too vague? That's when that kind of stuff can sort of come up. Um, we see when we see in our practice NDAs, and also they usually go hand in hand or often go hand in hand with a non-disparagement agreement, which is different. Non-disclosure is I'm not going to disclose X, Y, and Z sort of facts. And then the non-disparagement is I'm not going to say anything bad about you and trash your reputation or whatnot. We do, those are pretty common in employment agreements and in settlement agreements of employment cases. New York does have some restrictions on how they can be used in employment, in the employment context, and to settle claims of harassment or discrimination or whatnot. In that context, you are not allowed to have a liquidated damages clause. So, say, my client signs a non-disparagement agreement and they breach it, the defendant or the employer is going to have to prove their damages if they sue
Yeah.
them. It's pretty
But
common.
the attorney's fees piece is often pretty good leverage.
Yeah, yeah, exactly. Because if you have to sue to enforce it and then they win and you're on the hook for their attorney's fees, that's a deterrent. I mean, in our practice, I think we tend to feel that if you filed a lawsuit, if you've said your piece, if you've gotten, your justice and your closure, probably better to just not talk about this anymore in general, for sort of all parties. But um, yeah, but I thought this was interesting. I also, I didn't have enough time to do like a deep dive into whether this is a legal concept in this context, but I kind of wondered what the legal ramification could potentially be that he disclosed this information. I mean, he doesn't have an NDA about his own life necessarily, but he's, disclosing something that other people had been asked to be kept secret. And I think that at the very least, say there is no liquidated damages provision, I think you'd probably have a pretty good argument if you came out of the woodwork tomorrow and spilled the tea on this wedding. You could be like, well, I didn't cause any damage to you. You did it to yourself.
Yeah, it was
Like,
already public
just, or,
knowledge.
like some kind of a waiver
Yeah,
argument almost. If you're a part, I mean, theoretically, if he's, I don't know who the other party to the NDA is. I mean, you kind of have to have like some sort of mutuality for something to be enforceable.
yeah,
If he was some party to a confidentiality agreement and he breached it, I think there's probably some arguments to be made, that other people could maybe put in their 2 cents as well. Um, but I thought it was pretty, this was one
yeah.
of those like, did you think 10 steps down the road about how this was going to blow up and if whether it was going to work in your favor or not?
Yep. And we have to wrap here, but I did read a comment from David Beckham, which I thought was appropriate, where he said something to the effect of he's a kid and kids make mistakes. Like when they asked him about the kid releasing it, he was just like, yeah, he's stupid and he's not realizing what this means. But I don't know. All right, we
I
have
don't
to
know.
wrap.
This is kind of like the Italian in me is like, keep it in the family.
Yeah,
Somebody
yeah,
offended you, you pretend they're dead.
yeah.
You don't have to air your dirty laundry to the whole universe.
All right, we're gonna leave it there. Thanks everyone for listening. We'll be back again with some more legal discussion of stories in the news. If you have questions, please feel free to hit us up on Instagram at Litigious Podcast. Again, please feel free to subscribe, like, share, do all the things, and we will be back again soon. So thanks for listening.